Hi guys, it's Kathy. I hope you're doing well. I got another bar story because I work at a bar. It's a brewery, so it's not a real bar. Real bartenders should get offended when I say I work at a bar. But I have bourbon, vodka, tequila, rum. Hey! Anyway, so, people start drinking, especially when they're women at the bar. I try to, make sure that I'm watching what they're doing. Whatever they're doing, I'm watching them. If you walk into my bar and you are drinking an alcoholic beverage, I promise you, I am watching every single thing that you do. Not just to nail you for doing something bad. That's not the point. Because you're drinking, and people's inhibitions go away when they're drinking, and they also do stupid things when they're drinking. So Krista comes in. She's awesome. She's beautiful. She has real long hair, and she comes in often with her married friend, who comes in all the time with different men. We always wonder who Krista's married friend is gonna come in with, but Krista comes in alone. The married friend comes later, and there's Michael at the bar. Now, Michael started coming in almost every single day about a month ago, maybe. I don't know. And Michael sits right next to Krista. They don't know each other, and I thought that was really, really, really strange. Michael sits there. Okay, well, first off, Krista's beautiful. She really is. She's beautiful. So Michael sits next to Krista, and I'm watching. I'm watching. Krista's friend comes in. I'm watching, but I have other tables. I go out to a table, deliver some food, come back, and they're both saying, "Hey, Kathy, we both have the same birthday." No, they don't. No, they don't. The birthday that they both had was Krista's birthday, and Michael's like, "Yep, that's my birthday too." Oh my gosh! So Michael has her date of birth. Then later on, I hear her talking to both her friend and Michael. So she's sort of facing towards me, and she's like, "Yeah, my email, is my first name, last name, 49." And I'm like, okay, she didn't really give out her email since he already has her date of birth. She didn't really give out her email. She just said first name, last name. And it's fine. She's only told him her name is Krista. No problem. And that could be spelled many different ways. So far, she's safe. And, I'm telling her, now he has your birthday. And I say it right in front of him. Now he has your birthday. And now you're talking about your email. And she's like, what's he going to do? Email me? I said, what? So at the end of the night, they both pay. And then I hand them their credit card slips back. And yep, that's what he did. He says, let me see. And he looked right at her credit card slip, and he goes, oh, that's your last name. I said, Krista, now he has your email and your birth date. I said, hey, maybe your cell phones are one digit apart. You want to give him that too? And I was like, come on, girl, don't do that, girl. Why are you doing that to someone you just met at a bar? Guys, don't give people you just met at... If you want to give people you met at a bar information, it is perfectly fine to give them completely false information. Hi, my name is Justine. I was born in 74. Yep. He actually works as security. Not like the door security. He's one of those people that sit in the bubble above Boscov's. And if you don't have Boscov's where you are, above a big store. Walmart, I don't, and he watches the security cameras. So he knows a little bit about security. He knows better than to do that in front of me. When you go to a bar, guys, don't tell them anything. If you do, lie. Lie. It's fine. You're allowed to lie. It's way better that you lie than you tell them the truth. It's way safer to lie. And all you men who think, oh my God, all the women are lying to me at the bars. Yeah, it's called safety. I wonder why they have to be safe, men. And ladies. I'm sick of drunk people. They don't listen. They don't think. But they all love me. I love you. I love you. Okay, sure you do. Show it in the tip, baby. Show me. All right. We're going to go to Connecticut today. Two very, very, very different types of parole. Oh, I'm wrong. I'm wrong, guys. No. This is Indiana. Yeah. I'm sure. We're going to Indiana for just a regular docket. And then we're going to Connecticut for, maybe I'm drunk, for the parole. And when the parole comes on, it's inappropriate and great. But it is inappropriate. But it just keeps getting better. I love those. Okay, here we go.
Controlled substance, said location being a public place or place of public resort, and Caitlin Ray England either breached the peace or was in imminent danger of breaching the peace. Count 6, on or about March 4, 2025, in Montgomery County, state of Indiana, when Caitlin Ray England did communicate a threat to Molly Constance McGowan, another person, with the intent that Molly Constance McGowan be placed in fear that the threat will be carried out, and the threat was to commit a forcible felony, specifically screamed, quote, I'm going to fucking beat your ass, bitch, close quote, at her. Count 7, on or about March 4, 2025, in Montgomery County, state of Indiana, when Caitlin Ray England did knowingly or intentionally touch Charles England in a rude, insolent, or angry manner.
This is a different person, by the way, than the person that she's going to beat. And there she is.
Resulting in bodily injury, specifically struck him repeatedly. And count 8, on or about March 4, 2025, in Montgomery County, state of Indiana, when Caitlin Ray England did recklessly, knowingly, or intentionally perform an act that created a substantial risk of bodily injury to another person, specifically ran into Billy Null while angry, knocking him down. The charge is signed by Andrew Salter, Chief Deputy Prosecuting Attorney. Do you understand the charges you're facing?
Yes, ma'am.
Counts 1 and 3 are level 5 felonies, each of which is punishable by a sentence to the Department of Corrections of not less than 1 year, not more than 6 years, with an advisory sentence of 3 years. Each charge also carries with it a maximum fine of $10,000. Counts 2 and 6 are level 6 felonies, counts 2, 4, and 6 are each level 6 felonies, each of which is punishable by a sentence to the Department of Corrections of not less than 6 months, not more than 2 1/2 years, with an advisory sentence of 1 year. Each charge also carries with it a maximum fine of $10,000. Count 7 is a Class A misdemeanor, punishable by up to 1 year in the Montgomery County Jail, a fine of up to $5,000. Count 8 is a Class B misdemeanor, punishable by up to 180 days in the Montgomery County Jail, a fine of up to $1,000. Do you understand the penalties so far?
Yes, ma'am.
Level 5 felonies are subject to Class B credit time, which means if you are convicted of a level 5 felony, in order to serve an executed sentence, you would be required to serve 75% of your time instead of half. Do you understand?
Yes, ma'am.
For each of these battery offenses, if you are convicted of a battery offense, if you're charged again with another battery against the same person in the future, the state would file that new offense as a level 6 felony, regardless of the other facts and circumstances. Likewise, with the intimidation, if you are convicted of intimidation, if you're charged again with intimidation against the same individual in the future, the state would file that new offense as a level 6 felony, regardless of the other facts and circumstances. Do you understand the possible penalties you're facing?
Yes, ma'am.
You have certain constitutional rights that you carry with you throughout these proceedings. Those are your right to a public and speedy trial by jury. You have the right to be presumed innocent unless and until the state proves you guilty beyond a reasonable doubt to each element of an offense. You have the right to confront and cross-examine the witnesses against you, to see them, hear them, and ask them questions. You have the right to have witnesses appear, testify on your behalf, and to use the court subpoena power to make them come to court. You have the right against self-incrimination, or what people commonly call your right to remain silent. The fact that you don't testify can never be used against you. In fact, you don't have to call any witnesses or present any evidence whatsoever because the entire burden is on the state. You also have the right to testify in your own defense. Should you choose to exercise that right at trial, you would be subject to cross-examination, and your statements could be used against you. You have the right to appeal a conviction to a higher court of law. That would include your right to appeal the terms of any sentencing orders. You have the right to be represented by an attorney. If you cannot afford an attorney of your own choosing, the court would appoint an attorney to represent you. Do you understand your rights, ma'am?
Yes.
With respect to your right to counsel, do you wish to be represented by counsel?
Yeah, just point me to somebody.
If you'll raise your right hand to be sworn, we'll take some evidence to see if you qualify. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. Please state your name again for the record.
Caitlin Ray, England.
Ms. England, how long have you lived at this Voris Street address?
Honestly, just a couple months. I moved down here because my man got incarcerated too, and I wanted to be closer to him.
Who lives there with you?
Just his mom, Mary, his dad, Charles, his grandpa, Billy Knoll.
Do you pay rent there?
No, ma'am. I haven't had a job since my car accident in 23.
Do you have any children?
Just one. My mother has temporary guardianship over her, though.
How old is that child?
4 years old.
Do you either pay or receive support for that child?
No, ma'am. I want to do good. I want to get better for her, you know?
Do you own any real estate?
No, ma'am.
Do you have any cash available to you from any resource, a family member, a friend, under a mattress somewhere, on your books there at the jail?
No.
Do you have a bank account?
No.
Do you own a vehicle?
No.
Do you have any personal property with a value greater than $100, such as electronics, collectibles, appliances, jewelry, anything like that?
Not here.
Do you own those things?
I have, yeah, that house, that address that we were talking about.
The Vore Street address or the
Yeah.
Madison address?
4th Street.
Okay, what do you have there?
My cell phone and my clothes and all my personal belongings.
How much is your cell phone worth?
It's definitely worth, like, it's this iPhone 15 Pro, so it's worth a lot.
Okay, what's your best guess at how much you could get?
I'd say 300, 400.
Do you have any expectation of receiving any assets, cash, or property of any kind, such as an inheritance, lottery winnings, income tax refund, anything of that nature? Did you file a tax return for 2024?
No, we do.
Judge, if you let me out, I'll go get some scratch-offs from the Piggly Wiggly, and I might win. I might win some money in this week.
Because, well, my man did. He claimed me on his because I haven't worked since my accident.
All right, and so did he receive a tax refund?
Not yet.
Is he expecting one?
Yeah, he should be.
Do you know how much it is?
Not really. I'm not really in the known about how much is getting back.
Do you have any monthly expenses that you're responsible for paying?
No.
Where were you working in 2023 when you lost your job?
Out of a factory in Madison, Indiana. I was there for quite a few months.
How long were you there?
I'd say like 4 months. And then I got in my accident.
How much were they paying you?
About 15, 16 an hour on night shift.
How many hours a week were you getting?
40, 45.
Are you disabled?
I'm currently I just applied for
She doesn't know how much it is because she didn't pay for it.
disability a few months ago, and then I had to reapply because they're just so weird about applying. You have to apply
Isn't the judge great? She's so stern.
multiple times with them.
We'll find that you qualify for a public defender. We'll notify the public defender administrator, who will make an appropriate appointment of counsel for you. Your attorney will be in touch with you shortly. You're under a court order to maintain contact with their office, communicate with them as they direct, and assist in the preparation of your case. Do you understand that order?
Yes, ma'am.
The court's going to enter a preliminary plea of not guilty for you. It becomes a permanent plea in 20 days, unless after consulting with an attorney you decide to enter a different plea. The court's also obligated to set this matter for an omnibus date somewhere between 45 and 75 days from today's date. The court will set the matter for omnibus and status hearing on April 22nd at 9 a.m. for a jury trial July 22nd at 8:30 a.m.
Does that mean I'm being released?
We haven't discussed that yet. Do you understand those
sorry.
dates, ma'am?
Yes, ma'am.
Her phone almost costs as much as my car.
The court has made a finding of probable cause in this case and has entered no contact orders with respect to Billy Knoll, Charles England,
Mary.
and the court will enter one as to Mary England as well.
Okay.
You're not to have any contact with any of those people, and that means direct contact, indirect contact, third party, social media, Twitter, Snapchat, Facebook, email. No contact means no contact. If you should secure your release from jail and you violate the court's no contact order, you would be placed back in jail until your cases are resolved. If you violate the court's no contact order, you would face additional criminal charges. You do not want to do that. Do you understand?
No, I understand.
The court is going to find, based on the facts alleged in the probable cause affidavit, that Ms. England shall be held pending the posting of her bond. The court sets bond in the amount of $2,000 cash, given the nature of the charges that have been filed against you. Do you have any questions, ma'am?
No, ma'am.
Anything further, state?
No.
Anything further, Mr. Donaldson?
No.
That is all for today. Thank you.
So here's where I just nodded off a little bit, so we get the next one too,
Okay.
whether it's good, bad, or
All
ugly.
right, we'll see you later.
I see Celine Dion now that you guys said it. So I nodded off instead of clicking the end of this, but then I woke up while she was talking to this next person about their assets.
Hearing, how old are you, sir?
32.
How far did you go in school?
Graduated high school.
Do you read, write, and understand English?
Yes, ma'am.
At the time these charges were filed, the state had an address for you of 325 East Elm Street in Ladoga. Is that still your address?
It's my mailing address. It wasn't where I was living.
Where were you living?
In my van, or in my a van that my wife had bought for me.
What is your email address?
Ashburn K at 65.
What cell phone number do you use for text messaging?
Uh,
Mental illness.
yes, ma'am.
Can you tell me about that?
I suffer from psychosis due to schizoaffective disorder, PTSD, depression.
Are you currently under a doctor's care?
Yes, ma'am.
What agency is your doctor with?
Valley Oaks.
Are you currently prescribed any medications?
Yes, ma'am.
Do you know what you're taking?
Buspirone. I don't know the exact list, ma'am.
Okay, let me
Want
ask
my
you this,
email?
sir. Is there anything about your diagnosis or your medications or lack of medications, perhaps, which might impact your ability to understand the proceedings today?
Not today, ma'am.
Are you today under the influence of any alcohol, drugs, or other intoxicating substances?
No, ma'am.
Have you received a copy of the charging information?
Yes, ma'am.
You're charged in this case with 4 counts. Count 1 is residential entry, a level 6 felony. Count 2, domestic battery, a level 6 felony. Count 3, criminal mischief, a class B misdemeanor. Count 4, domestic battery, a level 6 felony. Count 1 reads in relevant part as follows. On or about February 28, 2025 in Montgomery County, state of Indiana, one Kyle Mackenzie Ashburn did knowingly or intentionally break and enter the dwelling of Jeffrey P. Ashburn. Count 2, on or about February 28, 2025 in Montgomery County, state of Indiana, one Kyle Mackenzie Ashburn, then being at least 18 years of age, did knowingly or intentionally touch Jeffrey P. Ashburn, a family or household member, in a rude, insolent, or angry manner, specifically threw him to the ground by his hair in the presence of children under the age of 16, knowing that a child under the age of 16 was physically present and might be able to see or hear the offense. Count 3, on or about February 28, 2025, in Montgomery County, state of Indiana, one Kyle Mackenzie Ashburn did, without the consent of Jeffrey P. Ashburn, recklessly, knowingly, or intentionally damage or deface the property of Jeffrey P. Ashburn, specifically a door belonging to Jeffrey P. Ashburn. Count 4, on or about February 28, 2025, in Montgomery County, state of Indiana, one Kyle Mackenzie Ashburn, then being at least 18 years of age, did knowingly or intentionally touch Ashley Ashburn, a family or household member, in a rude, insolent, or angry manner, specifically shoved her against the wall and grabbed her, causing pain in the presence of children under the age of 16, knowing that a child under the age of 16 was physically present and might be able to see or hear the offense. The charges are signed by Andrew Salter, Chief Deputy Prosecuting Attorney. Do you understand the charges you're facing, sir?
Yes, ma'am.
Counts 1, 2, and 4 are each level 6 felonies, each of which is punishable by a sentence to the Department of Corrections of not less than 6 months, not more than 2.5 years, with an advisory sentence of 1 year. Each charge also carries with it a maximum fine of $10,000. Count 3 is a Class B misdemeanor punishable by up to 180 days in the Montgomery County Jail, a fine of up to $1,000. Counts 2 and 4 are domestic batteries. What that means is if you're convicted of either count 2 or 4, if you're charged again with another domestic battery against any other victim in the future, the state would file that new offense as a level 6 felony, regardless of the other facts and circumstances. If you're convicted of either of these batteries, if you're charged again with another battery against the same victim in the future, the state would file that new offense as a level 5 felony, regardless of the other facts and circumstances. If you're convicted of any of these offenses, if the court makes a finding that it involves an issue of domestic violence, the court would issue a domestic violence order. You would incur a fee of $50. Any parenting time you have with minor children could be adversely affected. Your right to bear firearms would be adversely affected. Do you understand the possible penalties you're facing?
Yes, ma'am.
You have certain constitutional rights that you carry with you throughout these proceedings. Those are your right to a public and speedy trial by jury. You have the right to be presumed innocent unless and until the state proves you guilty beyond a reasonable doubt to each element of an offense. You have the right to confront and cross-examine the witnesses against you, to see them, hear them, and ask them questions. You have the right to have witnesses appear, testify on your behalf, and to use the court's subpoena power to make them come to court. You have the right against self-incrimination, or what people commonly call your right to remain silent. The fact that you don't testify can never be used against you. In fact, you don't have to call any witnesses or present any evidence whatsoever because the entire burden is on the state. You also have the right to testify in your own defense. Should you choose to exercise that right at trial, you would be subject to cross-examination, and your statements could be used against you. You have the right to appeal a conviction to a higher court of law. That would include your right to appeal the terms of any sentencing orders. You have the right to be represented by an attorney. If you cannot afford an attorney of your own choosing, the court would appoint an attorney to represent you. Do you understand the rights that you have, sir?
Yes, ma'am.
With respect to your right to counsel, do you wish to be represented by an attorney?
Yes, ma'am.
The court is aware that you have another case pending, that being 54D01 2411 F63374, wherein Mr. Donaldson was appointed to represent you. Is that correct?
Yes, ma'am.
Has your financial situation improved since Mr. Donaldson was appointed to represent you in that case?
No, ma'am.
The court will appoint Mr. Donaldson to represent you in this case as well. You remain under a court order to maintain contact with their office, communicate with them as they direct, and assist in the preparation of your case. Do you understand that order?
Yes, ma'am.
The court's going to enter a preliminary plea of not guilty for you. Becomes a permanent plea in 20 days unless after consulting with an attorney you decide to enter a different plea. The court's also obligated to set this matter for an omnibus date somewhere between 45 and 75 days from today's date. We'll set the matter for omnibus and status hearing on April 22nd at 9 a.m. for a jury trial July 22nd at 8:30 a.m. Absent further order from the court, that's when you're ordered to be back. Do you understand those dates, sir?
Yes, ma'am.
The court has made a finding of probable cause and will issue no contact orders with respect to Jeffrey Ashburn and Ashley Ashburn. If the state requests additional no contact
That is Lady Cassandra from Doctor Who. She always needs moisturized. Constantly. Moisturize me.
orders, the court will review those upon receipt.
Linus made me put her up.
You're not to have any contact with Jeffrey Ashburn or Ashley Ashburn, and that means direct contact, indirect contact, third-party social media, Twitter, Snapchat, Facebook, email. No contact means no contact. Do you understand, sir?
Yes, ma'am.
If you should violate the court's no contact order, you would face additional criminal charges. If you have secured your release from custody, then your release will be revoked. You'll be placed back into jail until your cases are resolved. So you do not want to do that. Do you understand?
Yes, ma'am.
The court is also entertained a request on a petition to revoke bond in your 2411 F6 3374 case. Based upon the filing of these new additional charges, the court has granted that request. So even if you post bond in this case, which the court will set in the amount of $1,000 cash, you will be held on the other case. So you will be held without bond in your first case. Do you understand, sir?
Yes, ma'am.
Do you have any questions?
Yes. I
nearest.
was told I needed to speak with you about a work release.
The nearest.
The court's not going to authorize work release, and frankly, you won't qualify for it based on the charges that have been filed against you.
Okay.
Any other questions, sir?
Is my attorney in the courtroom?
He's no longer in the courtroom.
Okay. No questions.
Anything further, state?
No, Your Honor.
All right, that is all for today. Thank you.
Thank you.
You're welcome.
Okay, it looks like I slept for longer than I thought, because that's not the person that I remember. This guy was older and he had a job. So, oh my goodness, look at how much sleep I got.
How far did you go in school?
Not him.
Some college.
Do you read, write, and understand English?
Yes, Your Honor.
At the time these charges were filed, the state had an address for you. What is your email address? What cell phone number do you use for text messaging? Do you suffer from any mental illness?
No, Your Honor.
To your knowledge, do you have a history of any mental illness or
Yes. YouTube-itis.
emotional disability?
No, Your Honor.
Are you today under the influence of any alcohol, drugs, or other intoxicating substances?
No, Your Honor.
Have you received a copy of the charging information in these cases?
Yes, Your Honor.
We're going to look at them in chronological order. So the first one is the 446 case. It's a 3-count information. Count 1 being possession of methamphetamine, a level 6 felony. Count 2, possession of paraphernalia, a class C misdemeanor. Count 3, possession of marijuana, a class B misdemeanor. Count 1, reason relevant part as follows. On or about September 13, 2024 in Montgomery County, state of Indiana. 1, Jordan David Kiger did knowingly possess pure or adulterated methamphetamine without a prescription or order of a practitioner acting in the scope of their professional practice. Count 2, on or about September 13, 2024 in Montgomery County, state of Indiana. 1, Jordan David Kiger did knowingly or intentionally possess an instrument, device, or other object, specifically a metal smoking device containing plant material that the defendant intended to use for introducing into the defendant's body a controlled substance. Count 3, on or about September 13, 2024 in Montgomery County, state of Indiana. 1, Jordan David Kiger did knowingly or intentionally possess marijuana, pure or adulterated. The charges are signed by Greg Miller, Deputy Prosecuting Attorney. Do you understand the charges you're facing? 2 1/2 years with an advisory sentence of 1 year. It also carries with it a maximum fine of $10,000. Count 2 is a Class C misdemeanor punishable by up to 60 days in the Montgomery County Jail, a fine of up to $500. Count 3 is a Class B misdemeanor punishable by up to 180 days in the Montgomery County Jail, a fine of up to $1,000. If you're convicted of either count 2 or 3, if you're charged again with the same offense later in your lifetime, the state would file those new offenses as Class A misdemeanors and the penalty would become more severe. Do you understand the possible penalties in that case?
Yes, Your Honor.
Turning our attention then to the F6552 case, it's a 4-count information. Count 1 is possession of paraphernalia, Class C misdemeanor. Count 2, possession of marijuana, Class B misdemeanor. Count 3, possession of syringe, a level 6 felony. Count 4, possession of methamphetamine, a level 6 felony. Count 1, reason relevant part as follows. On or about February 7, 2025 in Montgomery County, state of Indiana. 1, Jordan David Kiger did knowingly or intentionally possess an instrument, device, or other object, specifically a grinder, smoking device, and or spoon, that the defendant intended to use for introducing into the defendant's body a controlled substance. Count 2, on or about February 7, 2025 in Montgomery County, state of Indiana. 1, Jordan David Kiger did knowingly or intentionally possess marijuana, pure or adulterated. Count 3, on or about February 7, 2025 in Montgomery County, state of Indiana. 1, Jordan David Kiger with intent to violate the Indiana Legend Drug Act at Indiana Code 164219 or to commit an offense described in Indiana Code 3548-4, did knowingly possess or have under his control a hypodermic syringe or needle or an instrument adapted for the use of a legend drug or controlled substance by injection in a human being. Count 4, on or about February 7, 2025 in Montgomery County, state of Indiana. 1. Jordan David Kiger did knowingly possess pure or adulterated methamphetamine without a prescription or order of a practitioner acting in the scope of their professional practice. The charges are signed by Joseph Boozer, prosecuting attorney. Do you understand those charges, sir?
Yes, Your Honor.
Count 1 is a Class C misdemeanor. It is punishable by the same offense, possible penalties as the other C misdemeanor. Do you want me to go through those again with you?
No, Your Honor.
The Class B misdemeanor carries with it the same potential penalties as the Class B misdemeanor in the other case. Do you understand those penalties?
Yes, Your Honor.
And each of the level 6 felonies are punishable by the same possible penalties as the level 6 in the other case. Do you understand?
Yes, Your Honor.
Likewise, counts 1 and 2, if you're charged, if after a conviction, you're charged with the same offense later in your lifetime, the state would file that new offense as a Class A misdemeanor and the penalty would become more severe. Do you understand the possible penalties you're facing?
Yes, Your Honor.
You have certain constitutional rights that you carry with you throughout these proceedings. Those are your right to a public and speedy trial by jury. You have the right to be presumed innocent unless and until the state proves you guilty beyond a reasonable doubt to each element of an offense. You have the right to confront and cross-examine the witnesses against you, to see them, hear them, and ask them questions. You have the right to have witnesses appear, testify on your behalf, and to use the court subpoena power to make them come to court. You have the right against self-incrimination, or what people commonly call your right to remain silent. The fact that you don't testify can never be used against you. In fact, you don't have to call any witnesses or present any evidence whatsoever because the entire burden is on the state. You also have the right to testify in your own defense. Should you choose to exercise that right at trial, you would be subject to cross-examination, and your statements could be used against you. You have the right to appeal a conviction to a higher court of law. That would include your right to appeal the terms of any sentencing orders. You have the right to be represented by an attorney. If you cannot afford an attorney of your own choosing, the court would appoint an attorney to represent you. Do you understand your rights, sir?
Yes, Your Honor.
With respect to your right to counsel, do you wish to be represented by an attorney?
Sorry, as in a public defender or?
Well, I'm asking if you want to be represented by counsel.
Yes.
Do you have the means to hire your own, or are you asking for a public defender?
I currently have an attorney for my custody stuff that I'm going through right now. So I'm going to try and see if he is willing to take these cases also.
All right, we will show for today's purposes that you plan to hire your own counsel. I will advise you, Mr. Kiger, you need to make those arrangements sooner rather than later. I'm going to give you some dates here in a moment, and one of those is an omnibus date. There are certain motions that are tied to that omnibus date that some have to be filed a certain number of days prior to that date, some a certain number of days following that date. Those motions may or may not apply to your case, but some of those motions would be deemed waived if they're not timely filed. Do you understand?
Yes, Your Honor. I have a question. So if he's not able to take me, because I have been going through a custody thing for the whole last year and I've already paid quite a bit of money to him, so I'm pretty much strapped on money unless he's able to work with me. If I can't, how do I let you know that I'm not able to before my omnibus? Is it possible to do that?
Yeah, we're going to set it for an attorney status hearing, or you can write a letter to the court.
Okay, thank you.
You're welcome. The court's going to enter a preliminary plea of not guilty for you becomes a permanent plea in 20 days, unless after consulting with an attorney you decide to enter a different plea. The court's also obligated to set this matter for an omnibus date somewhere between 45 and 75 days from today's date. The court will set the matter for omnibus and status hearing on April 22nd at 9 a.m. We'll set the matter for jury trial July 22nd at 8:30 a.m. The court will set the matter for an attorney status conference on March 25th at 9 a.m. Absent further order from the court, that's when you're ordered to be back. Do you have any questions so far?
Yes, what was the most recent court date that I have? March 25th?
Yes.
Okay, sorry, you said April 1st, so that's why I was.
I never said April 1st. You have March.
No, I'm saying, sorry. Never mind.
March 25th at 9, April 22nd at 9, July 22nd at 8:30.
Thank you.
The court's going to set bond in each of these cases in the amount of $1,000. That's a total of $2,000 cash.
Thank you, Your Honor.
Anything further, State?
No, Your Honor.
Anything further, Mr. Kiger?
No, thank you.
That is all for today. Thank you.
Thank you.
But wait, there's some more. Hi, Donald. I'm trying to get something done that's very, very important. It's very, very important, Donald. It's very, very important. This is it.
Could you state your name for the record,
This
please?
is when I wake up.
David L. Richardson.
This is 54 DO1 2309 F6 3337, State of Indiana versus David Richardson. The record should reflect the defendant appears in the custody of the Montgomery County Jail by video for initial hearing. How old are you, sir?
I'm 47, ma'am.
How far did you go in school?
High school.
You graduated from high school?
Yes, ma'am.
Do you read, write, and understand English?
Yes, ma'am.
At the time these charges were filed, the state had an address for you of 207 North Main Street in Advance. Is that still your address?
Yes, ma'am.
What is your email address, sir?
David L. Richardson 77 at gmail.com.
What cell phone number do you use for text messaging? Thank you.
765-577-1317.
Do you suffer from any mental illness?
No, ma'am.
To your knowledge, do you have a history of any mental illness or emotional disability?
No, ma'am.
Are you today under the influence of any alcohol, drugs, or other intoxicating substances?
No, ma'am.
Have you received a copy of the charging information and the level 6 felony affidavit?
My paperwork here says misdemeanors.
There's also a level 6 felony affidavit. We'll read through all of that together today. We'll get that sent down to the jail to you. You're charged in this case with 2 counts. Count 1 being possession of marijuana, Class B misdemeanor. Count 2, carrying a handgun without a license, a Class A misdemeanor. Count 1 reads and relevant part as follows. On or about April 25th, 2022, at New Ross, Montgomery County, State of Indiana, when David L. Richardson did knowingly possess marijuana, pure or adulterated. Count 2, on or about April 25th, 2022, at New Ross, Montgomery County, State of Indiana, when David L. Richardson did knowingly or intentionally carry a handgun in a motor vehicle or upon the defendant's person without a license. The charges are signed by Joseph Boozer, prosecuting attorney. Do you understand those charges, sir?
Yes, ma'am.
Count 1 is a Class B misdemeanor, is punishable by up to 180 days in the Montgomery County Jail, a fine of up to $1,000. Count 2 is a Class A misdemeanor, punishable by up to 1 year in the Montgomery County Jail, a fine of up to $5,000. Do you understand those possible penalties?
Yes, ma'am.
There is a level 6 felony affidavit which is filed. It reads in relevant part as follows. David L. Richardson has previously been convicted of a drug offense, particularly possession of marijuana, and cause numbers 06D02 to 0306CM385 and 06D021410CM545. That in the incident cause, the defendant was found to be in possession of marijuana that weighed at least 30 grams, and the defendant has a prior conviction for a drug offense such that Indiana Code 3548411C serves to elevate the incident offense to a level 6 felony. That affidavit is signed by Joseph Boozer, prosecuting attorney, and subscribed and sworn to by Stacy Byers. Do you understand that affidavit?
Yes, ma'am.
What that means is if you are convicted of count 1, if the court finds that you have these prior convictions or one of these prior convictions, your conviction in this case becomes a level 6 felony, which is punishable by a sentence to the Department of Corrections of not less than 6 months, not more than 2.5 years, with an advisory sentence of 1 year. It also carries with it a maximum fine of $10,000. Do you understand the possible penalties you're facing?
Yes, ma'am.
You have certain constitutional rights that you carry with you throughout these proceedings. Those are your right to a public and speedy trial by jury, You have the right to be presumed innocent unless and until the state proves you guilty beyond a reasonable doubt to each element of an offense. You have the right to confront and cross-examine the witnesses against you, to see them, hear them, and ask them questions. You have the right to have witnesses appear, testify on your behalf, and to use the court subpoena power to make them come to court. You have the right against self-incrimination, or what people commonly call your right to remain silent. The fact that you don't testify can never be used against you. In fact, you don't have to call any witnesses or present any evidence whatsoever because the entire burden is on the state. You also have the right to testify in your own defense. Should you choose to exercise that right at trial, you would be subject to cross-examination, and your statements could be used against you. You have the right to appeal a conviction to a higher court of law. That would include your right to appeal the terms of any sentencing orders. You have the right to be represented by an attorney. If you could not afford an attorney of your own choosing, the court would appoint an attorney to represent you. Do you understand your rights, sir?
Yes, ma'am.
With respect to your right to counsel, do you wish to be represented by an attorney?
I probably need a proper attorney, ma'am.
If you raise your right hand to be sworn, we'll take some evidence to see if you qualify. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You put your hand down. Please state your name again for the record.
David L. Richardson.
Sir, how long have you lived at this Advance address?
Probably right around 15 years, ma'am.
Who lives there with you?
I'm separated from my wife right now.
So who lives there with you?
I live alone, ma'am.
And do you own that residence, or are you renting it?
I own.
How are you making mortgage payments, or do you own it free and clear?
Making mortgage
Yo, I was shopping, but I'm done now. I'm done. I'm back here now. It's very important.
payments, ma'am.
How much is that mortgage payment?
We're close to $500 a month, right around.
Do you have any children?
No, ma'am, just stepchildren.
This property that you're paying mortgage payments on, how much do you owe on it?
I still have about another $60,000 to pay it off.
And how much is it worth if you try to sell it?
I'm not.
A fireman came in tonight dressed in his fireman gear. It was awesome. He sat at table 5. Yes, he did. I was at table 5 often. Fletcher, thank you so much. I'm sorry I ignored you guys for like 10 minutes. I had to do something. I'm sorry.
Real sure, ma'am.
Well, your guess is
Probably-
probably better than mine. I might say 300,000.
Probably 100, maybe 100,000.
Do you have any cash available to you from any resource, a family member, a friend, under a mattress somewhere, on your books there at the jail?
I will have, ma'am.
Okay, how much will you have available to you?
I think about $300 coming towards me.
Do you have a bank account?
Yes, ma'am.
How much is in your bank account?
I'm not real sure because my wife's been paying some of the bills and stuff out of my bank account while I've been arrested. So there should be maybe about $1,500 into the bank account now.
Do you own any vehicles?
Not in my name, no, ma'am. I have a GMC Terrain, but it's got a lien on it.
What year is it?
I think it's a 2011.
Do you owe any money on it?
No,
How much is it worth if you try to sell it?
scrap, probably $300, ma'am.
What kind of lien does it have on it?
I think it's a back taxes lien. I'm not really sure.
What other vehicles do you and your wife own? Because those are marital property.
I have a Dodge, I guess it's a 2013 Dodge Avenger that we have together.
Do you owe any money on that?
I think there might be a few payments left, but it's real close to being paid off.
So what, around $600 or $800?
Yeah.
Yes.
Yes, ma'am. Sorry.
How much is it worth if you try to sell it?
Maybe 3,000 to 5,000.
Any other vehicles?
No, ma'am.
Any motorcycles or boats?
No, ma'am.
Any personal property with a value greater than $100, such as electronics, collectibles, appliances, jewelry, anything like that?
I have like TV at home. It's a Panasonic TV.
How much is it worth?
Probably 300.
Okay, what else?
I Just bought a bed, so it's probably worth $2,500. The bed is maybe.
Anything else?
Not that I can think of that would be worth selling.
Do you have any expectation of receiving any assets, cash, or property of any kind, such as an inheritance, lottery winnings, income tax refund, anything of that nature?
No, ma'am.
Are you employed, sir?
Yes, ma'am.
Where do you work?
Cruise Consulting out of Avon, Indiana. It's a surveying company.
How long have you worked there?
I'm going on my 5th year.
How much are they paying you?
I think I'm close to about $28 to $30 an hour.
And how many hours per week do you get?
40.
What are your monthly expenses, sir?
My house payment, my car payment to my father, utilities, propane, and then whatever it takes to manage the house, groceries, and things like that, ma'am.
Sir, based on the information you've given me, the court cannot find that you are indigent. First of all, you have assets that you could levy against to secure funds to retain counsel. You also are gainfully employed at a job where you have significant income or enough income that you can save money to hire an attorney. The court's going to deny your request for
I'm sorry, but Maiko, she would be great at swatting the fly, wouldn't she? She just would. I can't help it.
public defender. The court's going to enter a preliminary plea of not guilty for you. Becomes a permanent plea in 20 days unless after consulting with an attorney you decide to enter a different plea. The court's also obligated to set this matter for an omnibus date somewhere between 45 and 75 days from today's date. The court will set the matter for omnibus and status hearing on April 22nd at 9 a.m. for a jury trial July 22nd at 8:30 a.m. Court's going to set the matter for attorney status conference on April 1st at 9 a.m. Absent further order from the court, that's when you're ordered to be back. April 1st at 9, April 22nd at 9, July 22nd at 8:30. Do you understand those dates?
Yes, ma'am.
If you have hired an attorney who enters an appearance before April 1st, you don't need to come to that April 1st date because the sole purpose of that hearing is to determine whether or not you've secured counsel, and if not, what needs to transpire to assist that to happen. Do you understand, sir?
Yes, ma'am.
Do you have any questions, sir?
No, ma'am.
You have bond in the amount of $1,000 available to you. Why did you fail to appear at your October initial hearing in 2023?
Okay, guys, listen. We have 1 minute and 17 seconds left on this video, and then we're moving on to the next one. And it is absolutely inappropriate. It's not okay. It's just not okay. So, just so you know, it's inappropriate. You've been warned that if you stay, you are into inappropriate videos.
You've been wanted on warrant for a year and a half.
When I had my original tickets, they had a date on them. I showed up to the Montgomery County Courthouse. I went to a traffic court, I think. That judge said he had no paperwork on me and told me to go upstairs and talk to another judge. And they kept disagreeing with who I was supposed to see. So I finally gave my tickets to a tall, slender judge. And me and him had a conversation, and he told me if anything became of it, he would contact me and get a hold of me.
I think he meant slender, but did he say slither? A tall slither judge.
And I never got contacted, ma'am.
Well, it looks like we tried to serve you with a summons to appear on October 9th of 2023 once the paperwork was filed. We tried to serve you at 207 North Main Street in Advance, an address where you say you've lived for 15 years, and we couldn't serve you there. Why is that?
I have no idea because I still live there, ma'am.
All right, you have cash bond in the amount of $1,000 available to you. Do you have any questions, sir?
No, ma'am.
Anything further to state?
No, Your Honor.
That is all for today. Thank you.
Thank you, ma'am.
You're welcome.
So, here we go. Buckle up, babies. Here we go. You ready? I did warn you it's inappropriate. I did warn you. Kick her out, Toll Monkey. Kick her out. make her go sleep downstairs on the sofa. You can't hear me because my volume's low. I'm going to turn my volume up a little bit for this video. Oh, it's really high. I don't think so. I'm sorry, Toll Monkey, but if I turn it up any higher, I like blow the ears out of other people. There's nothing I can do. Okay. Remember a members only video where I no, never mind. I'm just going to play it.
Morning, Mr. Bennett.
Good morning.
Morning. We're here for your rescission hearing.
Yeah.
So we're going to get started with that, okay?
Okay.
I make $3 an hour doing this, Fletcher.
Good morning. I'm Appeal Meister, a hearing examiner for the Board of Pardons and Paroles. Can the board members who are present today please state your names for the record?
Good morning, I'm Jennifer Zaccanini.
Good morning, Mike Paul.
Good morning, Robert Sazowskis.
This is a rescission hearing concerning Bennett Julian number 403772. Today is March 6, 2025. This hearing is being conducted at HCC in the BOPP via video live stream. This is a public hearing and public access to this hearing is available via video live stream. Can you please state your name and inmate number for the record?
My name is Julian Andrew Bennett, inmate number 403772.
This is a rescission hearing to determine whether you have violated conditions of your release. I will review and make findings of fact to each of the charges against you. If I find you violated one or more conditions of your release, the board will consider whether or not your release should be rescinded. The decision made by the board today will be made final. This is an administrative hearing. The rules limiting the type of evidence admissible in a criminal trial do not apply in a parole rescission hearing. Disputed charges will be resolved by preponderance of the evidence. The preponderance of the evidence means the evidence that taken as a whole is more credible and convincing.
This is Connecticut.
Evidence offered in opposition to it. If at any time during the hearing you have a question about the procedure, feel free to ask me about it. At this hearing, you have certain rights, which I will now review with you. Did you receive the written notice of the hearing?
Yes, miss.
Did you receive a packet of information which includes the rescission notice and information supporting the charges against you?
Yes, miss.
You have a right to be represented by an attorney at this hearing. You may retain your own attorney. You can't afford an attorney. There are limited circumstances under which one may be appointed to you. Do you want to proceed without an attorney?
Yes, miss.
You have a right to submit relevant documentary evidence. Do you have any relevant documentary evidence to submit?
Other than what you provided me, no.
Okay. So at this hearing, you're trying to call voluntary witnesses or cross statement adverse witnesses. Do you have any witnesses to testify today?
No, miss.
Are you prepared to proceed with the hearing at this time?
Yes, miss.
I will review each charge and inform you of the information underlying the charge. I will then ask you to admit or deny each charge. We will give you an opportunity to respond to the charge. If you choose to make no reply to the charge, the hearing shall proceed and my decision will be made on the basis of the information available. At the conclusion of the fact-finding portion of the hearing, I will inform you of my findings. The hearing will then be turned over to the board to consider your suitability for re-release. So the testimony at today's hearing will be taken under oath. So, Mr. Bennett, can you please raise your right hand? You solemnly swear or solemnly affirm, as the case may be, that the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes, miss.
So I'm going to read the charge, which is charge 1, significant adverse information, public indecency DR, with an ST score is 2 or above. So while in custody, the offender received the following Class A disciplinary reports. 12725, interfering with safety and security. Mr. Bennett covered all the cell windows, obstructing the offender's view and did not respond to verbal commands. 12625, public indecency. Mr. Bennett was stroking his penis while making eye contact with the officer and stated you totally like it. And on 12325, interfere with safety and security. Mr. Bennett refused to recall and approach the officer's bubble, hitting the offender's bubble fan on the ground. Officer's bubble on the ground. Mr. Bennett had a sexual treatment score of 2 and received his DR on 12625 for public indecency. He has received 2 additional Class A disciplinary reports for interfering with safety and security since being granted every parole date. So would you like to respond to that charge at this time?
Which one?
What I just read you. Any of what I just read.
Yes, miss.
But
Okay, so the interfering with safety and security on 123. I'm gonna, because this is why I didn't ask for an attorney or anything, because I just came down here just to be honest, and that's just what you're gonna get from me. It was a shakedown conducted in my cell because my cellie was very, very mouthy. All he does is run his mouth to COs. The CO accidentally got my stuff mixed up with my cellie stuff. She threw in my personal pictures, and I asked to speak with the lieutenant or captain. They wouldn't allow me to speak with the lieutenant or captain. So, you know, I've come a long way because I have 288 tickets. I've come a very long way, so I learned how to, you know.
He just said he had 288 tickets. Most people have 4. 5. Man, if they have 8, the parole board loses their mind. He has 288. Most of them are indecency.
Speak and verbalize my needs and stuff like that. You know, this is without medication, you know, and all that. Like I'm doing this by myself, you know. And so being that I couldn't speak with a lieutenant or a captain, and I've been staying out of trouble for so long, I admit I got very frustrated, and the only way for me to get a lieutenant or a captain is to do what I did, and I did what I did. I'm not gonna sit here and lie to your face about this interfering with safety and security on 12325. I did do that, and I take full responsibility for it. Now that being said, when I got to RHU, Lieutenant Pearson, he explained to me that he understood the circumstances and everything that was going on. I was supposed to leave SAG on Monday with no ticket. They were going to throw that ticket out, okay? Now, as far as 126-2025, the public indecency ticket, I'm a man, okay? I'm in prison. I didn't know this lady was working. Her name is Ms. Whaler. I did not know she was working. There's 4 COs in the block in RHU, over there in Corrigan's Correctional Center. There's 4. 1 stays in the bubble. I did not know that she was working. Three male COs kept doing tours throughout the entire shift. I did not know that she was working. Now, being a prisoner, we're very sound prone, so when we hear keys, we know somebody's coming. So when you work in the bubble, you don't hold any keys on your person, so we won't know if you're coming. So I didn't know that she was working. So when she did the tour, when I see her, because in Corrigan there's big windows, there's 2 big windows, and then there's a cell door window. So I didn't know she was coming. I'm on my bunk laying down. So when I seen her head pop in the big window, automatically I pulled my covers up. I said, oh, excuse my language, oh, and she's like, oh, you knew I was effing coming. I'm like, miss, I did not know that you were coming, miss. She said, you knew I was coming. I said, miss, I didn't even know you were working. There were three male CEOs working this entire shift. I didn't even know you were here. You didn't say female on the tier. You didn't say anything, miss. She's like, no, you knew that. So I got up. I'm like, miss, I looked in her eye. I said, miss, I did not know that you were doing your tour, miss. She said, yeah, you did. You know, and all I said was, yeah, okay, you would like that. That's what I said. And she twisted my words around. And anyways, the deputy warden, the warden, Lieutenant Pearson, everybody, they know that I've come a long way, and there's no way that I'm going to sit there and mess up what I got going on by doing something stupid like that. So they were like, you know what? You're good, but you have to sign the ticket. I'm like, why would I want to sign the ticket that's just going to screw me even further? If you guys know that I didn't do it, why sign it? Don't just sign it, get out the way. I became frustrated, and I had caught another ticket because I felt like everything was just ruined. I felt like my chances of going home was ruined, and I did what do you call it? I did mess up again, and I ended up covering my window. This is the excuse me for a second. This is the 127-2025 interfering with safety or security ticket. I did cover my window. Chemical agent was utilized, and that was the end of that. Now, when I went to sign these tickets, I signed these tickets on 1/29/25, I signed these tickets, okay? And as far as the public indecency ticket, as you can see, I wasn't really given any sanctions, any PS time for it. The only quote unquote sanction that I was given, it was ran concurrent to the interfering ticket that I caught on 127, okay? And that's the only reason why I signed those 3 tickets, because they're like, listen, you sign the ticket, you go back to the block tomorrow, you don't have to worry about getting any significant sanctions on that public indecency. We're going to run that concurrent with another ticket, okay? Mind you, again, I got the deputy warden telling me, oh, you're fine. Parole's still going to let you parole. You didn't do anything violent. You didn't assault anybody, all this stuff, and here I am, looking like a fool. So I admit to the 2 interfering with safety and securities, but I give you my word as a man that public indecency was not intentional. I did not know that this lady was working. I did not know that. I on my grandmother's grave, I didn't know that she was working, and I explained this to them multiple times. And again, I only signed the tickets because I was given a deal, and I was given false promises. That was it.
Thank you for your explanation. So would you like to offer a partial admittance?
How in the hell was that an explanation? What did he say? Does anybody know what he even said? Something, I don't, yeah, okay, we'll just keep going.
The full admittance or denial of that charge?
Can I please get a denial, miss? I'm sorry, but I can't.
You want to deny all of that? Or you're saying you're partially denying just the indecency DR?
Yeah, what the indecency DR, like it was not intent. I didn't know that the lady was working. I told her that multiple times, and she just kept, oh, you knew, and I'm like, you know what, you would like that. That's what I said, and here she said she's twisted my words and said that I said you like it. What? That sounds like something out of a movie.
So you're offering a partial admittance. Is that correct?
Yes, miss.
So based on the information that I have and listening to testimony, I'm going to announce my findings now. So I do make a finding of violation on that charge 1, significant adverse information. This is based on evidence, which I find more credible than other testimony offered in opposition to it. So that includes a fact-finding portion. Should you be re-paroled, do you have a release plan, or what does that look like?
Yes, miss. I was supposed to get released to a halfway house. Right now, I have no family support. I done lost my family support. I lost my friend support. I would like to go to the Hartford. I was supposed to go to the Hartford area, but I've been thinking, and I feel like just to stay out the way, because I know Hartford too well, I would like to go somewhere like maybe like the Norwich area, if possible. If I have to go to the Hartford area, then get transferred to Norwich, I would do that. I just want to start fresh. I don't want, sometimes you got to go out your comfort zone in order to be successful. You know what I mean? And I want to try something new for once. I've been in Hartford most of my life.
We can put you for Norwich. We can put you down for there if that's where you'd like to go. Do you have any other plans when you get re-released back to the community?
Well, according to my parole stipulations, I have to do programs. So the way I have it set up in my mind is I would get a 3rd shift job. That way, during the day, I can get my programs done. Because that's the biggest thing about special parole. They want to make sure that you get your programs done, And I don't want to give special parole any reason to violate me this time around. Because again, all I have is myself, miss. You know what I mean? So I got to go 100 times harder because it's only me. I lost my family. I lost my friends, everybody. So it's only me. So I have to get a job. I'm 30 years old with no license. I have to get a driver's license. I'm 30 years old with no apartment. I have to get an apartment. I'm 30 years old with no high school diploma. I have to get a diploma. It's not time to play around. It's time to get my life in perspective. I'm 30 years old with nothing to my name,
What do you want to do for work?
Apparently, it's always time to play around. So just so you know, if you go to jail and you do something like that in your own cell while you're, sleeping or whatever, that's public indecency.
For what? I want to get back to CNA. I was loving it. I was doing CNA for Dax Foundation in East Hartford, Connecticut, and it was everything. So I would love to get back to CNA.
Is there anything else you want to say before I turn it over to the parole board?
That's about it, miss. That's about it.
So I'm going to make a note on the record that Mr. Bennett's parole date was February 10th, 2025. His end of special parole date is February 8th, 2027. I don't know if it's over to the panel chair.
Thank you very much. So, Mr. Bennett,
Yes, miss.
I'm very concerned about your behavior, sir. And I'm not sure why you're stuck on the fact that you didn't know there was a female corrections officer working, because it doesn't matter. You know the rules because you've had many public indecency disciplinary reports. It doesn't matter if there's a female, a male, you broke the rules. What's most concerning to me is that you pick up these disciplinary reports knowing that you're waiting to get re-paroled and go back out to the community. Do you not want to be out?
No, I really do want to be out,
Okay,
miss.
so is it a matter of self-control? Can you not control yourself?
That's not the case, miss, at all.
But that's what it appears. With 100 tickets, I can't tell you how rare it is that we see someone with that many tickets during one incarceration. With 100 tickets, and you violated your parole with multiple violations too. It wasn't just doing one thing. You were doing everything wrong. So I'm having trouble understanding how we can help you. You do realize we can keep you. We could just take your parole right, rescind
He knows exactly how you can help him, ma'am.
it, and keep you till February 8th of 27. Do you understand that?
I do.
Okay.
And
So help me understand why we should believe that you're a good candidate for parole and should be put back out.
because, miss, out of those 100 tickets, I went home last year in February, and I came back, unfortunately, in August. And I've only caught those 3 tickets since I've been back since August, miss. And if you ask anybody, and to comment on your on what you said about the past public indecencies, that was the Northern days when Northern was open. I felt like everybody felt like it was an okay thing, and it took for this older dude to tell me one day, he's like, "Oh, listen, you have a mom?" I said, "Yeah." He's like, "Where's your mom?" I said, "She's in Jamaica." She was like, "You have nieces?" I said, "Yeah." He said, "How would you feel if somebody did that to your nieces?" And I said, you know what? I would feel some type of way about that, and that's why I stopped doing stuff like that. Okay, so I'm telling you, miss, like, I've come a long way. All I hear is "Good job, Bennett. Good job. You've been doing good job." Don't let that set you back, and and
that's fine. I'm not going to take away. I'm not going to take away from the progress that you've made. But for you to say I've only received 3 tickets since August, that's 3 too many, in my opinion.
True indeed.
You should receive any when you're waiting to go back out into the community where you should want to be and where you should want to be successful. I want to know how we can help you, because we don't want to keep seeing you back here.
Miss, I understand where you're coming from. It looks horrible on paper, and I should never did what I did. I apologize. That's the best I can give
Right.
you, Miss.
So what's going to keep you on the straight and narrow and out of trouble when you go back out to the community?
The fact that I'm going to have things to look forward to, the fact that, again, Miss, I'm 30 years old with nothing to my name, and it's time for me to make something in my life. The longer I sit, Miss, I don't know if you guys were informed, but I just passed out yesterday due to the stress, because I'm so stressed out from being in here. You know what I mean? And I did it to myself. At the end of the day, I caught these tickets. I did that to myself, And again, I apologize sincerely. I apologize. I can't express how sorry I am. It's like, and I understand where your frustration is coming from, because it's like you see so many people who have no tickets. You know what I mean? And you guys grant them parole. But here I am. I'm catching tickets, messing up. You know what I mean? And I haven't messed up since then, and I don't plan on messing up again, Miss, because
I did see that. You haven't had any new tickets. And I hope that you now understand that if we give you a new date and you get more tickets, you're going to have to come back again.
Yes, Miss, and I'm not going through that, Miss. It's time for me to get my life together. I'm tired of this, Miss. I'm 30 years old, but zero to my name, zero, nothing.
What are you doing right now in the facility?
Right now, it's hard to get into programs here. So I really just sit back and listen to podcasts, motivational podcasts and stuff. I wrote to get in school, but they told me that I'm not going to be able to get into it because I'm probably.
What about volunteer programs? There's some voluntary stuff you can do.
Like what?
Meetings or. Where is he? Where are you?
Hartford. Yeah, Hartford Correctional. It's very hard to get into programs here.
Yeah. I did note that you're staying out of trouble.
He's not done.
And motivational podcasts are probably a good idea.
Yeah,
If it
and
helps you.
I listen to other things too, like spiritual podcasts as well, because the only thing I have on my tablet right now is just podcasts. So I try to do anything to feed the mind, you know. And
Right. And what I would suggest to you, if you do get a new parole date, is that you really take advantage of all the programs. While it might seem like a nuisance and sometimes you don't want to go, you can always benefit from any kind of education. So be open to it. If you can find ways to learn greater self-control or to walk away from situations, then that's only going to benefit you, not anybody else. We don't send you to programs to help us. We don't benefit at all. You understand?
Yes, miss.
All right, Mr. Pohl?
Thank you. Mr. Bennett, do you know when your tickets, when your time runs out on your tickets?
If I caught the last one on the 27th, I believe it's 120 days from the 27th of January, if I'm not mistaken.
And I don't have anything further. You covered it.
Thank you. Mr. Selasco?
He's answered all of my questions. Thank you.
All right. Give us a few minutes to discuss your case amongst ourselves, okay? We'll come back to you with a decision. All right, so here's where I stand. I do see some progress since the...
This parole board, they have the discussion amongst each other right in front of him. He's not allowed to talk. Hi, quietly. He's not allowed to talk while they discuss.
Since these tickets. And he does sound good today. It sounds like he has a plan and he's going to try. He's interested in participating in programs and wants to do CNA work and what have you. I am not willing to release him before these tickets clear. So we're looking at
May 27th.
Yeah, I mean, I don't know the exact date, but yeah, so that would be a, actually, yeah, I would do 4 months from his vote to parole date. Do the same sanction that DOC does. Well, it's February, so March, April, May, June. Yeah, you're right. June, yeah. I don't know. What are your thoughts? Anybody?
I agree. Yeah, I agree. Yeah, I was thinking, probably once for each one of these.
Yeah. Okay. All right. So in the matter of Julian Bennett, inmate number 403772, I'll make a motion to rescind his parole and re-parole after a 3-month sanction on May 10th, 2025, with the previous conditions that include halfway house placement, programs for domestic violence and anger management in the community, general no contact with initials NC without parole officer's permission, and mental health treatment with medication compliance. I think it was something different prior.
Evals on.
Yeah. Can we change it to mental health treatment?
I don't think we can just change it in case of the evaluation completed first.
Okay. All right. Mental health evaluation and treatment if deemed necessary. Is there a second to motion?
Just clarification.
Yeah.
You went from June to May.
I covered him.
I mean, I'm sorry.
Yeah.
Oh, thank you. Yes. So,
I am not
I said the wrong
Donald.
thing. Let's start over. In the matter of
Listen, if I'm going to get in trouble for something, I'm going to do it. Just so you know. Look at Charlotte. She does look just like you, Donald. Just like you. Oh, baby. Congratulations. She's not the only new baby. There's just so many babies in Discord right now. Whoops. Hold on. Let's not forget security. Look, security, congratulations. Linus doesn't have a one right at the very end of chat. I would have to scroll up too long. But then we also have Linus. So many babies. I can smell the pictures. Do you ever see a baby picture and you can just smell that picture? Man. All right, we have 45 seconds, Fozzie. Can I finish real quick? I should have looked him in the eye when I said that.
William Bennett, 403772. Thank you. I'll make a motion to rescind parole and re-parole after a 4-month sanction on June 10th, 2025 with the previously mentioned conditions.
Second.
All in favor?
Aye.
Aye.
All right, Mr. Bennett, you understand? You have any questions?
No, miss.
All right, good luck.
Keep working on yourself, Mr. Bennett, okay? Please don't come back. Try your
Yes,
best.
miss. Yes, miss. And I apologize again to all of you.
No more tickets.
Yes, miss.
Linus is an ant. An ant. An ant.
All right, you're all set. Thank you.
All right, thank you. Have a blessed day.
And then he's stuck for another 120 days till his ticket's clear. And that's if he does not get another ticket. Keep working on that. Yeah, I didn't like that. I didn't like that yes, miss the whole time. That bothered the heck out of me. But that's fine. That's okay. Oh, whew, that scared me. Okay. Time for Judge Fletcher.
I don't consider this a client conference.
It's just, the bottom line is, she's supposed to be here. We've given her the courtesy over, over.
But so here's the thing, I'm saying this for the courts, just a suggestion. So she did just show us a certificate. She was able to scrape together some funds to complete a 4-hour DWI education program. That's good, step in the right direction.
Maybe she saved up her beer money for it.
Well, she's been kicked out,
But
right?
she is, so we've got an offer of time served, okay, on a DWI first. And she's already done a lot of programs and things like this. And I know how the court feels about public safety and DWI. So we're offering the fact that she has done this program. She has done other DWI education type programs while she was in PTI. But the fact that her financial resources are now drained, she's kind of stuck in California with no means, no money, no nothing. It just makes sense to get this off the court's docket by having her, now we can get her a little additional time to get a bus ticket or something. Come here, get this off your docket, take care of it.
Today was for.
I understand.
We gave her, how 3 weeks?
Yes, Judge.
I cannot, obviously I have no control over her finances or her financial resources or her job prospects. But I'm hoping now that we do have, we literally are staring at the finish line. And all we need to do, literally scrape together a bus ticket, get her here. It'll take this case off your docket. We're done. One more setting, we can set it for a plea and she'll be done. Otherwise
Monday. She has until Monday.
No, but if he issues a warrant, doesn't she get a free ride from California to Houston, Texas?
If she's not here Monday, then I'm revoking the bond. That's it.
Okay, I'll see what I can make.
And I can't, 430 days old. We've literally 3 times
I appreciate your
reset
time
it to get her here.
giving her that opportunity.
How much is a bus ticket from?
Honestly, more expensive than you'd think. And I can't even imagine. Can you imagine riding a Greyhound from California to Houston? I can't even imagine that. I can, a lot of stops. If they drive straight through, that'd be one thing. You stop in every tiny little town along the way. So
I think that we've been more than accommodating.
You have been. You have been.
I'm not going past Monday. At some point, I think that she's just toying with us where she can't borrow or somehow
So if I
find
thought
it.
that, I wouldn't be here advocating the way that I am.
How do I know that?
Well, none of us know.
Right. So that's why she could be just toying with us. How do we know? So I'll give her till Monday. If she's not here Monday, I'm revoking the bond.
Okay.
And that's it.
Thank you.
Okay, for sure. Hey.
Just a reminder, we have that arena.
Oh, okay. No, Sebastian, come on.
Okay, Monday, guys.
Just we're approaching on Mr. Glover. We're trying to work out a plea. I think the only sorry?
Me?
Yeah, Judge. So basically he has a parole hold and I'm not sure.
Is he in custody?
And the credit didn't accrue. He's been in custody since January 2nd, but the credit hasn't been accruing under the cause.
Oh, he's under, obviously if he's in jail, I'm going to give you the credit.
Okay,
I just need to know that he's been in continuous custody and not out.
Okay, perfect. That was what we.
Because he's showing on bond for both of our cases, but, right. Let me see when the parole hold is placed. 1, 2. Of course, I'm going to give it to you, man. Come on.
We'll write up the paperwork. All right, thank you.
Was there ever any doubt, Will?
No, I knew.
Yeah, especially to get the paperwork was, up there, their due
Bye,
diligence.
Will.
You ready? Yeah.
All right, Judge. Page 12, Ashburn, come on up.
Hi, Gooch.
I will say that should be easy. From what I'm looking at.
Maybe a chance.
So I can fix that and then.
Hustle, lady, hustle. Let's go. Get up there.
So once it does work, I will put it in the stamp copy up and then the applications for the letters being due. And it'll make.
Oh,
Would you like to sit down, ma'am?
before.
Yes, thank you. I don't know.
Good morning, Ms. Harper.
Good morning.
Ma'am, you were charged with assault causing bodily injury. You were facing a year in jail and a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
On January 28th, 2024, an officer was dispatched to an Avis rental car in Houston, Harris County, Texas for an assault call. Upon arrival, the officer spoke with the complainant, who stated she is an employee at the business. The complainant stated that a week before, the defendant was at the business returning a car, and the defendant stated there was a mistake on the receipt that needed to be corrected. The complainant stated that she could not make corrections, but her manager could when he came back next Wednesday. The defendant returned a day before the next Wednesday, and the defendant became upset because she believed the complainant told her to return that day. The defendant began to cause a disturbance. The complainant turned her back to the defendant behind the service desk and saw the defendant grab a clear plastic medium-sized display holder from the service counter and throw it at the complainant, hitting her upper thigh area. The corner where the display frame made contact with the complainant's thigh shattered into small pieces, causing pain. The complainant stated she was calling the cops. The complainant was able to capture a picture of the vehicle, and the defendant was seen getting in. The complainant was able to capture a picture of the vehicle the defendant was seen getting into and driving off in. The complainant was able to give a license plate number. The vehicle was registered to the defendant, and the complainant positively identified the defendant by a previous booking photo.
Got it. All right, Ms. Harper, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to go back to this, was it Enterprise or Avis?
Avis rental car.
Not to go back to this Avis, not to have any contact with the complaining witness, and not to be in possession of weapons. Do you understand? These are your bond conditions. If you violate these conditions, a warrant for your arrest will be issued. You will be put into custody. No more PR bonds. Do you mind following those conditions?
Okay.
Ma'am, would you like to apply for a court-appointed lawyer? Okay. Deputy Mayor, do you mind giving an application? I'm going to give you an application. I need you to fill it out for me. I need you to sign a reset with Victoria. Then we'll have you just take a seat in the jury box while we get everything ready, and then I'll have you talk to the lawyer here momentarily. Okay? Please, and take your time. No, I mean for the person who's doing it, for defendants.
Yes, for sure,
It is a lot more work.
for sure. Because you don't have to get time out to get everything together.
Maybe we can try to set up a meeting with, like, I guess, is it Bernadette? I mean,
It's for Miss Guys.
Ms. Judge Guy? Okay. Maybe we can, I'll send her an email to see what we can do. Maybe setting like a,
Yeah,
you know.
because I mean, even we did these two as far as like what she was looking for, and we did ask questions.
Okay, I'll send her an email and then I'll include you and then we'll, yeah. You too, likewise. Thanks for coming. You ready? Hi.
Good morning.
Good morning.
So I have Guadalupe Guerrero on docket today. I wanted to talk to you about his bond. He picked up a VPO. So I just wanted to see if you were going to revoke his bond. He has no bond in felony and I have no arguments.
Is he in custody?
Yes, sir.
BDR as well, Judge.
Oh, he picked up a felony BPO.
And one for us. I don't have any arguments, Judge.
Not Mr. Guerrero, please. Yeah. Lupe. I don't even know what happened, so let's figure it out. I mean, all I know is that this is a third BPO. You know?
Correct. The state has made an offer. He wants to think about it. If we can get a reset until after his felony court date, which is next month, I believe, April 23rd. And then on our next setting, he'll let us know.
Did you offer?
I'm Sebastian.
Or is this?
Sebastian offered a tentative offer of maybe 90 days. He didn't put it in yet, though.
Okay. It'd be interesting to see. Is there an offer upstairs too? Do you know?
Let me check.
I mean, it's a new case. It's like,
It's brand new.
I can't imagine there is. It was filed, 5 days ago. So
Yeah.
No offer on the case.
Yeah.
I mean, theoretically, we could have a hearing to hold him at no bond. You know,
I leave it to the court. He has no bond upstairs. Regardless, he's going to be here.
let's see what they said. You need translating?
No, he speaks Dutch.
Good morning, Mr. Guerrero. With us, you have picked up a terroristic threat in January of this year. A month later, you pick up a violation of protective order. It's now come to my attention that you've picked up yet another violation of protective order. I have no idea what happened in that new case. We're going to find out. You have the right to remain silent. Anything you say can and will be used against you. The felony.
The felony? Okay, yes, Judge. On February 28th, 2025, an officer was dispatched to a suspicious persons call at a residence in Harris County, Texas. On scene, the officer observed the defendant across the street from the complainant's house. The complainant advised that she made multiple reports on the defendant, and on January 28th, 2025, the defendant was ordered not to go within 200 feet of the complainant's residence as a part of a MOA. The defendant was at her residence on February 27th, 2025, and stayed about 20 minutes and knocked on a window. On February 28th, 2025, the defendant returned and the complainant observed the defendant sitting on her porch.
So the newest one is from the 28th, just gets filed in March.
Yes. Yes.
Do we know if any threats or anything like that happened?
No threats are alleged. We've made 2 attempts to reach out to the complainant since the incident, and she hasn't answered yet.
JK, thank you so much. I appreciate it.
We have court orders for a reason, you know? We don't like to just put people in jail willy-nilly for shies and giggles. And I get that you have nowhere else to go, but a court order is a court order. You know, if you ever have any issues, come back, talk to us. Perhaps we can work something out, but you just can't do stuff on your own. It's not the worst, right? So what I'll do is I'm just gonna raise the terrorist threat by $1. Okay? I'm not gonna give you a bond reduction yet on the new case. So on the VPO, the violation case that you have with us, the bond is set at 25,000. On the terroristic threat, your bond is set at 2,500. You have a PR bond on that case. I'm going to yank the PR bond because we can't just continue to do this. I'm only going to raise it up by $1, but I don't know if you're going to get out, but how do we get your attention, Mr. Guerrero? You know, what do we do? No.
Lock him up.
No. So I am now going to place a leg monitor on
Be
you.
right back, guys.
If you get released, I'm putting a monitor on you and I'm giving you 1,000 feet radius that you're not to go where she lives or where she works. Do you understand?
Yes, sir.
I don't know if you're going to get out because you're being held at no bond on felony case, but if you do, just don't go back. That's all we're asking you to do. Okay, so
We're gonna get a reset until after the felony, so he can think about it, the offer, and see what's happening there, and then
okay, so the felony's set for
April
April
23rd.
23rd. You want to do the day after?
Yeah.
Okay.
The day after.
I'm sorry, but we just come back. We can find you a place to stay, Mr. Guerrero. Doesn't have to be like this. Really. All right. Good luck, Fred. So I need him to sign conditions before he takes off. So
I'll need a later.
Felicia, so GPS prior to release, no weapons, no going within 1,000 feet of lives, works, and then prior to release.
Yes,
And then, so 2501.
Yeah.
Please. On the terrorist threat, Guerrero. Hey, how are you?
I'm doing fine, thanks. Hernandez Quinteros is on your docket today. Spoke with the DA earlier and they just completed the RIP and but just released and I don't have it yet.
Okay, we'll give you a couple weeks. It's old, so at the next setting, if you want PTI, please have everything ready. It looks like mitigation on everything now.
It's supposed to be okay.
Sure, thank you, but just be ready. Pack it. Okay, if you want it. Okay. Take care.
Judge, you were revoking and raising on both of the Guerrero pieces or just the terrorist?
Terrorist threat by $1. Okay, machine.
Good morning, Your Honor.
Hey.
I'm approaching on Kevin Caesar.
Okay.
And he has accepted the Clean and Green program and we.
Is this what we talked about then?
Yes. And so we paid the fee, submitted the contract and signed up for the earliest date, February 7th.
Did they get a hold of him for the thing?
So I emailed the prosecutor. He said someone called him, but he didn't know who. Yeah. And he said, are you willing to do it early? He said, yes. So then I was like, did they call you back? Because they said they would call him back. No. So I emailed the prosecutor assigned to the case and said, this is what happened. We're willing to do it early. Can we do it? And she said, I can't help you. Go log in. And I logged in and the earliest date was May 28th. And we already have April 30th.
Okay, so just keep it.
I'm trying to get it done, but.
Don't worry about it. It's not a big deal. We'll set you, I guess, a couple
May
days
1st or
after.
2nd or something. Yeah, okay.
Okay, thank you.
I was going to approach on a plea for Kevin Halbert.
I'm ready to do this. Mr. Halbert? Are you ready?
She told me it's open to you. I have no idea.
Oh.
Oh, I'm sorry.
On Halbert?
Yes. I apologize.
You're talking about something else? You're doing good. Don't worry about it. So he's going in now?
Yes.
Okay. Good morning, Mr. Halbert. Mr. Halbert, you're charged with assault and bodily injury. You're facing a year in jail and or a $4,000 fine. All right, so Mr. Halbert, you're charged with assault, bodily injury. You're facing a year in jail and or a $4,000 fine. You have worked out an agreement. They're offering you 135 days in jail with credit for the 35 days that you've done. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accuser. If you're not a citizen, there are possible immigration consequences. You can be deported excluded from the country, denied naturalization, you give up the right to appeal. Once you plead guilty, it will go on your record. It's going to be there forever. From now on, you're facing a minimum of 90 days in jail. Do you understand? You still want to do this? How do you plead to the assault? Guilty or not guilty? I'll find you guilty, sentence you to the agreement, and we'll take you into custody now to serve your sentence. Well, good luck to you, sir. Thanks. So, Deputy Miranda, we need to take him into custody now. He's going in. Do you need him still?
No, I'm just gonna.
Yeah, he's got time, he's doing, right?
You gotta do 10 days.
Yeah.
Hi, Bill. I was gonna say you don't need to watch this because you've already seen it, but do you really watch your own stream? I don't. I don't watch my own stream.
Oh, I see it. I see it. Okay, I missed it. So it says here, I acknowledge receipt of the conditions of my probation and any attachments added. I understand that by not abiding by the conditions of my probation can be revoked and the court may sentence me in accordance with the law. In addition, I waive extradition for any probation revocation proceeding.
Bill, Fozzie has some eye contact for you.
In this matter.
Okay. So when do you want to reset it, Amy?
So the 30 days would be reset to 4.
Okay.
Here, let me give this to you because we don't need that. And then I'll enter it. Here we go.
Jen, thank you so much.
Have you spoken to him yet? Is he here?
No, he's not here. I spoke to him 3 days ago. I've got contact information for him though. Well, like a family member.
Do you want to put him on the docket for tomorrow so you can explain it to him? So he knows?
Yes, especially since it's a lengthier reset. I'll let his family know, but if we
put him on for tomorrow so that she can at least contact with him and let him know what's going on. Okay.
That'd be great. Thank you so much, Judge.
And then that way, and then after tomorrow, you can set him for that, whatever the date is that year. Okay. Trey, anything else?
Nope, that's it. See you tomorrow, Judge.
Okay, see you.
Thank you, Judge.
Thanks, Amy. Ms. Tichy.
Good morning, Judge.
Hi.
I'm here on Miss Malveaux, Deja Malveaux, the mother with the son. Her appearance was waived today, and we got a short reset for the state to get in touch with the son, and I believe that they
appearance is
have.
waived, so we're not interested. There we go. Oh, we got Will and Hair. I love it. Come on.
We finished with the PTI?
Or I'm setting a case for trial. And then we'll respond to the, allegations. But I'm not happy with her. I'm not going to acquiesce. She's doing whatever she wants to do. You need to reach out to her now that if she continues, then I'm going to take appropriate action. I'm not going to agree to this now. I mean, she has a week left. Let her do what she needs to do, but she's continuing to do what she wants to do anyways. And please reach out and let
Me too. Kit Kat, you're good. You're fine.
her know that or let him know that no means no.
Jen, you should rewind it a little bit if you want to laugh. Work sucks. I know. Thank you, Fozzie. Thank you so much. Thank you.
Okay.
All right, Judge, I will
Thanks.
tell her that the court was put on notice of the violations and is now either get it dismissed or
We'll
we're
have it
going to go to
heard.
trial. That's kind of hard on me though, Judge, because I was just appointed, but I'm being punished for it, but can we address that on?
Set it for trial. If she's not done by Wednesday, then.
Okay, thank you so much.
All right. Ms. Strong.
Hello, Elio Jose Guerrero.
Hold on a second. Real quick. I have it to them. You ready?
Yes, sir.
Good morning, Mr. Glover. Got it. Okay, so Mr. Glover, you picked up a burglary of a motor vehicle. You've also picked up an assault of a family member. On both of those cases, you're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're offering you 120 days in jail with credit for the 66 on the assault and 68 days on the burglary of a motor vehicle. You need to understand that both of these cases will go on your record. They will be there for the rest of your life. On the assault case, there's an affirmative finding of family violence, meaning if you pick up another one of these, you will be facing a 3rd-degree felony, 2 to 10 of the penitentiary. And if you've been to the pen, it could be just, they can continue to enhance your punishment, perhaps 5 to life, 15 to life. Do you understand?
Yes, sir.
On the burglary of a motor vehicle, that is also an enhanceable offense, meaning you continue to pick up those cases. At some point, they'll hit you with a felony on that as well. Do you understand? So from now on, you're facing a minimum of 90 days in any misdemeanor court here in the state of Texas. Any misdemeanor you pick up, it's a minimum of 90 days in jail. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, there's no turning around. This is stuck. It'll be there forever. Is this what you want to do? So you also need to understand that if you're on parole, pleading guilty to both of these cases, they may revoke your parole, sending you back to prison. What is ISF? I don't know what's going to happen, but they can revoke your parole, send you back to prison. Do you understand?
Yes, sir.
You still want to do all this? How do you plead to the assault and the burglary of a motor vehicle? Guilty or not guilty?
Yes.
I'm going to find you guilty. I will sentence you to both cases. I'm going to roll your court costs so you won't owe anything. Good luck to you, Mr. Glover.
Love.
Thanks, Will.
Thanks, Judge.
All right, Ms. Strong, I'm sorry.
Okay, so we have Jose Guerrero. This is an old case. It's from 2020.
You have another Guerrero?
Yes, I do.
Okay.
Yes, it's an old case. It's from 2023. The state wanted a 30-day reset to look over the case to
There's a
see.
2B warrant, Judge.
Okay. Is discovery complete on the case?
It said the 911 call is still in progress. It was requested on the 14th, but I mean, if it's from 2023, I don't know if they would still have records for 911.
Does anyone know anything about that? Have you seen any of that from Judge Ricky? Just that picture alone makes me think that is high quality. That is high quality content up in there. Does anybody know? Did a whole bunch of people show it? If you tell me a whole bunch of people you didn't see it, hold on, let me strike that. If you tell me you've seen it, a whole bunch of streams, I'm not even going to look at it. But if y'all tell me that you've not seen this and you don't know what it is, then I'm going to alright, I'm going to look at this. It's a YouTube judge, but it looks interesting, so I'm going to check it out. Bye, CJ Love. Sorry, back to our...
Yeah, I think they keep them, what is...
Oh wait, no, that's on the phone. I apologize. Yes, discovery is completed.
Nice.
Besides, we need to subpoena for the medical records.
Do you have an offer in the case?
No offer yet because this case just came onto my docket, so I'm trying to reach out to the complainant to see if I can get in contact with him first before I make any offer.
Okay. So he's really just, it's been in...
Yes. The first setting on this case was on January 13th, 2025.
Yeah, so they filed it to be December of 23. And looks like he didn't get picked up until, January of this year. So we'll just give you like a normal, just, right. So it's like, how long have you been on it? Did you just get appointed?
Yes, well, I've been on since the January
Do like
settings.
I mean, you don't have to just have 30 days, normal, because it's been in just the 2 weeks. Okay.
Okay.
Yeah.
Judge, I'm approaching on an off docket. If I can just give you the cause number 1 second.
We'll let him talk for another second.
So Judge, are you ready for the cause number? It's a 252-6711. It's a Nicholas Marina Odiambo.
Okay.
And Judge, I just want to get ahead of this. He has a bond violation report that I think is, if it hasn't been filed yet, it'll be filed soon.
I see it.
Okay, Judge, he missed a drug test.
Is he here now?
Judge, he went to Arizona. His mother's in the hospital. She's diabetic and she has a lot of health problems and she broke her ankle. And so he went to Arizona kind of as a family emergency to take care of her.
Let's do this. I'm gonna give him a week to go to a Quest diagnostic.
Okay.
And get it to us. If he doesn't, then I'm gonna revoke his bond.
Yes, Judge, for that, I will have to make an amended order on him. I can't do anything right now. He's actually been on the computer for like the last 30 minutes because everything is broken. But as soon as I can, I think that's
Okay.
into it.
So
we got it.
he has a week to go to Quest and get the result to us. If he doesn't get it done, then
He said that he could be back by about April 9th. He's just been taking care of his,
but
he wants within the next week.
it's supposed to, right. So
Have him
he's
go to Quest
let
Diagnostics.
everybody know, so you know what I mean?
Is there a particular drug panel you want him to get or is there a comprehensive
You
one?
can get that information from pretrial services.
Okay.
Just tell him to
Hey,
call.
but it has to be Quest,
Quest Diagnostics,
like
okay.
not Punka City drug testing.
Right.
Right,
Okay.
okay.
Punka City. I got a doctrine from there, I think. I don't know. I have to look through my paperwork. All right, guys. We made it to the end. Thank you so much. Did he really? Sorry, I got distracted. Interesting. Thank you so much for coming out today. I really, really, really appreciate it. This should redirect you right over to OJ. If not, I will see you all soon. I hope you guys have a great day. Thank you.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Her eyes near a sky so blue. In her jokes there's a truth so true. Wicked stream she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm.